Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we are coming to you from our central Washington locations. And yes, that is the Teanaway River, and it is rolling back there. But speaking of rolling, as we know, the United States Supreme Court has been on quite a roll the last couple years, especially when it comes into reining in many of these very problematic alphabet agencies. Well, news came out today that the United States Supreme Court has accepted review on a huge case involving a huge issue that could have very, very far-reaching implications on the ATF, the FBI, and all the other alphabet agencies. So, today, let's spend a few minutes and talk about how the Supreme Court will crush the ATF and other alphabet agencies. Okay, so the case we're talking about today is Looper Bright Enterprises v. Raimondo. Now, I know some of you are asking yourself, what the hell does this have anything to do with us? Well, I'm going to connect the dots in just a few moments. The lawsuit is brought by a bunch of fishermen who fish in the Atlantic, where apparently they are required to pay the salary of government employees that are on the boat to monitor their conduct. That's right, the private entity has to pay the salaries of the government employees that are on the fishing vessels, and they are mandated to be there by the administrative regulations of the National Marine Fisheries Services, okay? Now, what's happening here is that the National Marine Fisheries Services is saying, hey, listen, under the Chevron doctrine, we believe that when we take a look at all the regulations that govern fisheries, that this is the way the statute was meant to be enforced. This is the way the statute was meant to be interpreted. And yeah, all of you fishermen, you're on the hook for all of our salary. The big issue here is that they are asking the court to revisit the Chevron Deference, okay? The Chevron Deference, which was created in the case in 1984 of Chevron v. National Resources Defense Council. And in a nutshell, what the Chevron Deference says is, listen, if a federal statute is ambiguous, subject to more than one interpretation, then what happens is the federal agency tasked with regulating that industry, they get to tell us what the law means. Does that sound familiar? Because, oh God, we know how the ATF has used that to their advantage time and time again. Now, there actually is a two-part test if you really want to geek out with it. The first part, of course, is the court has to decide, does the statute speak directly to it? If it does, then the statute's not ambiguous and we don't even need to get into anybody's else's interpretation. However, if the court does believe that the statute is ambiguous, then that regulatory agency has the ability to interpret the statute. Now, how does that affect us? Well, we have seen this interpretation over and over and over. Take a look at how the ATF has changed directions on pistol braces. Take a look at how they changed directions on forced reset triggers, wide open triggers, and the list goes on and on and on of all the times that the ATF said, yep, we're totally cool with this, only to later on, for no reason other than political pressure, say, you know what, no, this is highly illegal. Now, I know some other people out here in the YouTuberverse are making a huge deal that this is going to absolutely crush the ATF. Is it going to hurt the ATF? It is. But you see, I don't believe that the Chevron deference is applicable to anything that the ATF does. As a matter of fact, the ATF has even so much as acknowledged that in some of their briefings. You see, because what the ATF regulates is statutes that can put us in prison, okay? We're not talking about fishery regulations as to who's going to pay whose salary. When the ATF's involved, we're talking about United States codes that if you're in violation of that, you're going to be a felon and you're going to go to prison. And the case law is extremely clear that when we're talking about criminal statutes, we don't get into a Chevron deference. Rather, it is the rule of lenity. And the rule of lenity says that if a criminal statute is subject to two interpretations, we will adopt the interpretation of the defendant so that the law has its least restrictive application. Now, of course, this news has some on the gun-grabbing left and the left in general completely freaking out because, oh my God, statutes might start being interpreted once again by the court. Consider what Texas law professor Steve Vladeck recently said to CNN about this case. The idea that agencies should be allowed to resolve ambiguities in statutes that they enforce has been a central feature of modern administrative law. If it's up to courts rather than agencies to resolve ambiguities, even in statutes delegating highly technical authority to the executive branch, that will give the courts more power and the executive branch less on everything from environmental regulation to immigration to public health to meat inspections to telecommunications policies. In that respect, it's consistent with the current conservative majority's pattern of weakening the administrative state in favor of judicial power to answer all of these questions. And what I would say to the professor is, well, you see, professor, you teach law and you know this, that the Article 3 branch of government, well, their sole purpose is, in fact, to interpret the meaning of statutes. Now, the bottom line is this, is that this case, likely we will not have a ruling until probably sometime 2024. I think there will be a lot of things that happen between the lawful and responsible gun owner nationwide and the ATF between now and then. Does this case have the ability to choke the ATF out? To some degree, it does. Does it have the ability to choke out a lot of the other alphabet agencies? Oh my goodness, it most certainly does. And that, in my opinion, is a good thing. Listen, you may have more questions about this case or anything else related to your Second Amendment rights. If you do, you should know how to contact Washington Gun Law by now, but if you don't, that's okay. All of that information is right there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.